Welcome to INN's Student. INN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Kavita Verma. She is going to speak on legal competence and capacity to contract in India. She is from KES Shri Jayantilal H. Patel College of Law. So without wasting further time, I would request her to commence with the lecture. Thank you.
Hello everyone, myself Kavita Verma and I am here to deliver words on the topic of legal competence and capacity to contract in India. In the most showroom, movie theatres or mall, one would not see children shopping for things for themselves on their own without the assistance of their parents. Similarly, you would not see the person with the unsound mind making purchase on high value on their own. This is primarily because due to their immature minds or mental disorder, they are unable to understand the consequences of their action. That is purchase, booking tickets, signing deals, etc. However, the modern times, children commonly shop for groceries, daily essentials and stationery products on their own without any assistance of their parents. Their peculiarity gives rise to the legal discussions around the capacity to contract and lead to the legal question. That is, can all individuals be allowed to enter into the contract? In the Indian legal system, the principle of contractual relationship are covered by the Indian Contract Act 1872, which concern itself with important aspects of contractual relations. The provisions of the enactment discuss the validity of the contract, out of which the most significant are the legal aspects of an individual capacity to contract. By capacity, one understands the ability of an individual to enter into the contractual relationship which we deemed valid by law. Due to their conditions, limitations and disabilities are unable to understand the consequences of the entering into the contract and thereby being unable to perform their ends of the agreement effectively. Now we can understand that is what is capacity to contract. Here section 2H of the Indian Contract Act 1872 defines the contract as any agreement enforceable by law. Further, section 2E defines agreement as every promise or set of promise forming consideration for each other. Promise simply means an assurance to do some act or omit from doing an act. So when two people promise each other to either do or omit from doing any act, they are said to enter into the agreement. An agreement, when it is enforceable by law, it is become a valid legal essential contract. Further, section 11 says that who is competent to contract. Every person is competent to contract who is age of majority according to the law and which he is subject, and who is of sound mind and is not disqualified from contracting by law of his subject. Three essentials: who are not incompetent to the contract, that is minor, person of unsound mind and person disqualified by law. Contract with minors, that is, as per section 3 of the Indian Majority Act 1875, every person living in India shall be considered to be a major once he becomes completed his 18th years of age. He is the general rule regarding age of majority, that the person is considered to be the minor till he attains the age of 18. The provisions, however, creates an exception by stating that the special case where the person or property or both belonging to some below 18 years of age is entrusted in the custody of an appointed guardian or the court of wards, he is considered a major only after attaining 21 years of the age. There is an exception that if there is a special case that a minor is under 18 years, after attaining the 21 years of age, he can contract to the party. Further, we can understand this better by the illustration, that is, a 16-year-old boy lost his parents due to an accident. The court appointed his parental uncle, a respectable man, that is, as a guardian of the boy, and the boy's property belonging to the boy which he is inherent after his parents' untimely death. In this case, boy can only enter into a valid contract after the age of 21 years. However, as per the current law, boy can be allowed to enter into the valid contract after attaining the age of 18 years. Position of agreement by the minor, that is validity. An agreement with the minor is void ab initio. A minor has received any benefits under the void contract. He cannot be asked to return the same. If the minor has received any benefits under the void contract, he cannot be asked to return for the same. Fraudulent representation by the minor, no difference is a status of agreement. The contract remains void. The minor, with the consent of all the partners, be admitted to the benefit of the existing partnership. Contract entered into the minor are void ab initio, hence no specific performance can be enforced for the such contracts. Minors' parents, guardians are not liable to the minors' creditors for the breach of contract by the minors. A minor can act as an agent but not personally liable, but he cannot be principal. A minor cannot be adjudicated as insolvent. He can enter into the contract by appreciable and service, education, etc. Guarantees by any minors. Minors can be treated as a trade union members. Second, that is contract with person of unsound mind. Largely, the principle governing a contract with the minor remains similarly applicable on the contract with the person of unsound mind. Therefore, in the Indian context, the contract with the person of unsound mind are absolutely void. What is unsound mind? One need to understand is who is person of unsound mind. According to section 12 of the Indian Contract Act, the person is said to be an unsound mind of the purpose of making contract if at the time when he make it, he is capable of understanding it or forming a rational judgment as it affect upon its interest. In simpler terms, we can say that person of unsound mind is a person who is not capable of understanding the consequences of entering into the contract and the terms which is contract imposed on him. Then second, it is not capable of comprehending the obligations arising from the contract and therefore cannot be expected to fulfill them. Unsoundness of mind includes the below three special categories, that is idiot, lunatic and drunken. Idiot, a person who has an unsound mind or insane since his birth. Lunatic, a person who has acquired the mental illness leading to an unsound mind after birth due to the disease or an injury. Drunken, a person who is in intoxicated situation which makes him incapable of understanding the consequences of his action. Burden of proof is basically the next legal issue, that is arises how to prove whether some of the person of unsound mind. The Supreme Court held that the burden of proof is on the person that challenged the validity of the contract. In situation where the person has periods of lucidity and period of lunacy, the fact that the person was a period of lucidity, clear minds while entering into the contract must be proved by the person who claims so. The burden of proof to prove that the person is unsound mind is that the person who repudiated the contract on the ground of unsoundness of mind. Example, that is intoxication can be also lead to the unsoundness of mind. Contract with the person disqualified by the law. This is our third point, that is after minor a people of unsound mind who require protection of law, that is the category which prevented from entering into the contract due to the legal disability is known as the person disqualified by law. This disability arises due to financial, social, political positions of these people may belongs to. That is certain categories of individuals under this portion are given below. That is alien enemies, foreign sovereign ambassadors, convicts, insolvent. First is alien enemies. Alien enemies are basically people who are citizens of foreign country. Alien friends are belonging to the country which has friend relationship with the Republic of India. And alien enemies are those who share hostiles or relationship or are a conflict with the India. Alien friends and alien enemies with the permission of the central government can sue in India court and competent to try the suit as if they are Indian citizens. However, alien enemies without any permission to the central government and those residing outside India cannot sue in India court. There are two categories of cases which emerge there, that is contract during war or conflict, or second, contract before war or conflict. Foreign sovereigns and ambassadors, that is the second point, that is these categories of people usually enjoy certain privileges which are granted by them by law. They are also given diplomatic immunities against being sued in Indian court. They can only be sued if they agree to admit themselves by the jurisdiction of Indian court. Therefore, they are allowed to enforce contract in Indian court, but no contract can be enforced against them without their approval of the central government. Third is convict, that is the conviction who are serving a sentence or punishment for central criminal offence are disqualified from entering into the contract. Once their sentence ends, the disqualification also ends. If the sentence, they are free to enter into the contract, they can do. They can also enter into the contract during peril or when they are pardoned by courts. Fourth or the last one is that all the estate or property of the person declares to be insolvent. Our fourth topic is insolvent, is vested on the hand of the official assignee who is appointed by the court. Hence, the insolvent person lack of power or capacity to enter into the contract with regards to those properties, as he cannot sue and cannot be sued by anyone else. Once the insolvency becomes an end, he is free to enter into the contract. Last, I would conclude my words with that the contracts are essentials to sustain daily life and for the progress of human civilization, but certain members of the society need the protection of the law to be prohibited from exploitation. That is exactly why the limitation is imposed on the certain categories of people from contracting. Even though with the incompetent people are allowed to provide them with the benefit of entering into the contract by creating such balanced legal systems of rights and obligations. In Indian legal system creates a wholesome approach towards the concept of capacity to contract while changing global and social dynamics. The change that these principles takes are yet to be seen. Thank you so much.
Kavita, thank you very much for giving a nice overview of capacity of persons who can contract in India. A small token from Hammurabi to you.
Thank you, sir.